Good afternoon to everyone. I'm audible?
Yes.
So welcome to this webinar, first webinar of the Legal and Regulatory Committee. It's my pleasure to welcome all of you. So let me first start welcoming our all honorable speakers, Mr. Andrew GORIUS, Dr. Tanja Sovic, and Mr. Umakanta Panigrahi, and Mr. Munish Sudan, and Ms. Anushka Sachdev. So the EU Chamber of Commerce, under the aegis of a legal and regulatory committee, is organizing this webinar, which we feel is of great importance. Just to give you a very brief about the Chamber of Commerce, Council of EU Chamber of Commerce. And today we have with us Mr. Sohail Nathani, who is the chairman of the Legal and Regulatory Committee of the EU Chamber. We have Mr. Krrishan Singhania, who is sitting just beside me. He is the co-chairperson of the committee. So this organization, the Council of EU Chamber, was formed precisely in 1992 with the objective to promote the business, trade, and the cultural relation between European Union and India. So over the years, we have been trying to assist our companies who have an interest in EU and vice versa. So we work very closely with all the Indian embassy, European embassies, as well as the various chamber of commerce, which are based in different parts of the European Union. And as an organization, our activity encompasses few things, like for example, assisting the companies whenever they need any support in terms of business, trade, or even the culture. And so our membership is more than 1,000. And we have the companies from across sector and across geography. And of course, we have a European companies based in India as well as overseas, and the Indian companies. The Indian companies generally, when they become the member, they should either doing the business with EU or they have an interest. So this is in very nutshell about the organization. And apart from that, we have some 7 sector committees. These sector committees have been formed with the objective to brainstorm and to also undertake the goal of the organization. So we have 7 sector committees: BFSI, consultancy and services, education, legal and regulatory, shipping, logistics, tourism, hospitality, and manufacturing. So this is one of the activity which we are organizing under the legal and regulatory committee, and we have already prepared a plan of action for whole of year, and which has been already shared with all the members. So we would request you and encourage you to participate in the activities, because this is something motivate us. And time to time we also conduct the survey, asking members view how they would like us to take the initiative of the chamber forward. And we would also welcome you after this webinar. Please give us your feedback. You will be getting a link to fill the form, feedback form, and we would be really happy to get your feedback. This will encourage us to take the activities in the right direction. With this word, I would rest my welcome remarks, and I would request Mr. Sohail Nathani, who is the chairman of the committee, to initiate the topic. And so over to you, Mr. Nathani.
Thank you, Dr. Shom. Welcome, everybody. On behalf of my co-chair, KG Singhania, and the entire committee, we are delighted to invite you to what is our first webinar of the year. We are all here today to discuss the vital connection between intellectual property valuation and technology transfer, and why this relationship is especially critical for Indian and European companies in 2025. Technology transfer enables the movement of innovations from research institutions to industry, where they become products and services that drive economic growth. However, for this process to succeed, it is essential to assign a monetary value to intellectual property assets such as patents and copyrights. This IP valuation underpins commercialization, licensing, and strategic partnerships by enabling fair negotiations and informed investments, not to speak of the tax ramifications of these valuations. Turning to the strategic importance of technology transfer in India and EU, both partners face a rapidly changing global technological landscape and recognize that cooperation is key to innovation and economic security. The India-EU Trade and Technology Council, TTC, established in 2022, has become a cornerstone of this partnership. It facilitates collaboration in critical sectors like semiconductors, artificial intelligence, and green technologies. Recent initiatives under the TTC highlight this momentum. In 2025, India and the EU launched two major research projects with a joint investment of about 41 million euro, focusing on marine plastic litter and waste to green hydrogen, addressing shared environmental challenges through innovation. The partnership on semiconductors has deepened since 2023 with the joint R&D in chip design, sustainable technologies, and talent development to strengthen supply chains and reduce reliance on external sources. Collaboration on digital public infrastructure aims to ensure interoperability with recognition of e-signatures to boost cross-border digital transactions. Both sides are advancing joint projects in AI and high-performance computing, focusing on ethical AI, large language modules, and building trusted AI ecosystems. The EU's new Choose Europe for Science program with a $500 million euro budget for 2025 to 27 seeks to attract Indian researchers, facilitating talent mobility and integration into European research. These initiatives also support the partners' ambitious climate goals, net zero by 2050 for EU and by 2070 for India, by fostering clean and green technologies, enabling market uptake through joint innovation and cooperation between incubators, SMEs, and startups. In summary, the interplay of IP valuation and technology transfer is central to unlocking the full potential of India-EU cooperation. This partnership not only drives innovation in strategic sectors, but also strengthens economic resilience, talent exchange, and sustainable development for both regions. Before I wrap up, I would like to thank young Shruti Singhania, who has taken the lead on this seminar. Thank you, Shruti, for all your initiative on this. I look forward to our engaging discussions today. With this, I'd like to hand it over to Shruti and the entire panel. Thank you.
Yeah, thank you, Mr. Nathani. Before we start the panel discussion, today we have a panel of some distinguished experts in the field of tech transfer, IP valuation, and IP law. So I'll just quickly introduce all the panelists and then we can start our panel discussion. My first panelist is Dr. André GORIUS. He is a veteran in the industry and has more than 30 years of experience. He has held C-suite positions, executive VP in R&D and industrial operations in companies in France, USA, and Italy. He's also an international IP valuation expert for WIPO. He presently consults and advises companies on IP valuation, R&D, and IP strategy. He's also the founding member and the board member of AMAVI, which is an organization that has an IP valuation certification program. And he intends to get that program to India, perhaps this year. So thank you, Dr. André, for joining us today. Next, we have Dr. Tanja Sovic. She is the head of patent and license management at Vienna University of Technology. She's also the founder of Tanja Sovic Consulting and has a PhD in polymer chemistry. She has extensive experience in patenting and commercializing the inventions from the university and taking it to the industry. She plays an active role as a member of the Task Force Innovation for CESAER, which is the Conference of European Schools for Advanced Engineering Education and Research. And she's also the chair of the Licensing Executive Society International Innovation Trends Committee. So thank you, Tanja, for your time today. Next, we have Mr. Umakanta Panigrahi. He is the managing director of the Valuation Advisory Services at Kroll, Mumbai, and he oversees India's financial valuation practice. With over 20 years of experience, he specializes in valuation of businesses, portfolios, IP, and financial instruments. He also manages financial advisory projects across sectors like energy, private equity, healthcare, and IT. And he's also skilled in valuing early stage companies with complex structures and has experience in distressed debt, earnout, and ESOP structuring. Thank you, Mr. Umakanta, for joining us. Our fourth panelist is Mr. Munish Sudan. He's the head of intellectual property and technology intelligence at Tata Steel. So he partners with the R&D to commercialize innovations. He also teaches IP and innovation at XLRI Jamshedpur. He's a certified licensing professional and also registered to practice before the Indian Patent Office. He has over 20 years of cross-sector experience. Previously, he has also led ValueServe's global IP team and has been instrumental in high-impact transactions in clean tech, personal care, and advanced material. He is also an inventor and holds 5 patents and has also co-authored IP strategy ebooks. So thank you, sir, for joining us. And our fifth panelist is Anushka Sajve. She's a technology, privacy, and IP lawyer practicing at Timelex, which is a law firm based in Brussels. She has expertise in both EU and India laws, and she has expertise in drafting and reviewing data processing, sharing and licensing agreements, and guides her clients on AI data governance and international data transfer. She also supports EU-funded research projects on data protection in AI and conducts workshops for consortium partners. And prior to Timelex, she has worked in some top India and Belgium law firms. So thank you all the panelists for joining us. And to briefly introduce myself, I'm Srishti Singhania, the moderator for today, and I'm an IP and corporate lawyer representing my law firm, Singhania and Company. So our firm is based in Mumbai, and we have about more than 30 years of experience in IP, commercial laws, and dispute resolution. And our focus is helping EU companies do business in India. We also specialize in a few sectors, which is shipping, aviation, and construction. So now that I've introduced everyone, let us, I think, jump into the topic of discussion, which is IP valuation and technology transfer. So before I think we need to understand actually the first thing that for laying down the foundation, we need to understand what is the technology transfer process exactly and what is adopted in the EU, right from the invention disclosure to the commercialization. So Dr. Tanja, can you share with us the entire process and what are the various models of commercialization?
Of course. First of all, thank you very much for the invitation and hi everyone. So I am working now at the Technology Transfer Office of TU Wien for more than 18 years. And what I have learned is that we should start with the awareness. Especially we have at the universities, we have lots of students or PhD students who are coming to the universities, leaving it, and the new ones are coming, which means we should repeat awareness all the time. What is intellectual property? Why are we doing it? And after that, we should also explain them why is it important if they have some invention to come to us to patent it. There are lots of people, they still think if they patent, they cannot publish it. So for us, it's also very important to raise that awareness. You can publish it immediately after the patent application, but please come to us. And when we get the invention disclosures, the Austrian laws says that we have maximum 3 months time to decide whether we want to claim the rights on the invention from the employees or not. So if we don't do anything, the invention goes to the inventors, to the employees. So we have this maximum 3 months to do the evaluation of the inventions. And this is actually in most of the countries, in most of the European countries, it's the same. So during the evaluation, first of all, we have to do prior art search, the market search. We need to talk to the researcher and to tell them it's very, very important that we work together. So because we are discussing everything together and the whole process, we cannot do it without inventors. So we are discussing with them the time, in which stage is the technology, how much financing and how much time they need until they reach the market, what is necessary, what do they need, what kind of fundings do they need. Is it also possible that we see if somebody is using our patent or not? And after all this evaluation process, if we decide to claim the rights, then we are mostly patenting it. And it depends. So strategy from our university is most patenting in Austria. So we start in Austria, then we go to the international phase, and afterwards we're deciding, depending on the market research and depending on the companies we are talking to, we are deciding which other markets are important for us. And regarding commercialization, so immediately after the patent application, we start with the marketing of the invention as well as commercialization. Marketing is very, very important because it's most of the technologies are early stage technologies, which means we need to market them. We need often partners who can help us develop the technology further to a higher technology readiness level. We want to raise also visibility of the inventors and of the work they are doing. And of course, at the very beginning, we are asking them what kind of commercialization do they have in mind? So do they want to found a company? Or maybe lots of them, they want just to be a researcher, and then we are talking maybe to other people who want to found a company, or we are searching for corporates who can be interested in that. And regarding the startups and spin-offs, so in Europe we had already lots of initiatives, but now in the last years it increased a lot, which means, for example, in Austria at TU Wien, they founded Startup Factory. This is our 100% daughter that should support the founders from the initial idea to the market. So it should cover the whole process. And at the same time, TU Wien and together with Speed Invest, they founded Noctur Science Ventures. And they should also provide targeted financing and strategic advice to the founders. So it's at the moment, it's lots of initiatives are going on, and so we have lots of very motivated people who now are thinking about a foundation of startups.
Yeah, thank you, Tanja. I think you shared a very interesting point about awareness, and it's very important for the inventors and researchers to know, like, when they can patent and whether they can publish their research after patenting. I think that's one of their concerns. So I think it's important that the inventors know about how to protect their patent and know-how. So I would request Mr. Munish to share with us, how can the inventors protect their patent and know-how during the technology transfer process.
Thank you, Srishti. I hope I am audible.
Yes.
Okay. Hello, everyone. Srishti, when we talk about technology transfer, of course, patents are important, know-how is important, but I'll also add another aspect to technology transfer, a process, that's the confidential information. And I'll touch upon each one of these, why these are important in the whole process. First of all, we need to understand in the dynamic world that we are living in, where innovation cycles are becoming shorter and shorter. There are complexities associated with technologies There are complexities associated with laws across the world. And more importantly, we also need to understand the technical world has become very mobile. And when I say technical world has become very mobile, I'm talking about the inventors, I'm talking about the employees working in different technical organizations. So when we are uh, developing a technology transfer strategy, we need to take into account all these aspects. To give you one example, just to set the context, and I'll come to the specifics of your questions. Suppose if you are coming up with a new invention or a new improvement, and the innovation cycle in that particular domain is say 2 to 3 years. Now it's not a question whether you can get a patent or not. It's a question how you can extract value out of it. And that's where whether to go for patent, whether to keep it confidential. And when we talk about industrial technologies, the concept of know-how, which may not be very pertinent and very particularly known in several of the industry, becomes very, very important. And what is know-how? Actually, it's a tacit knowledge, which is very difficult to record or put on paper, which you can only learn when you work on the shop floor. And to pass on that knowledge, it's very important that you also get trained, you also learn that while working. Now, when we talk about industrial technology development or any manufacturing technology development, we need to understand certain generic principles. And we talk about technology development on TRL scale, what we call as a technology readiness level. And typically, if we talk about readiness levels 1 to 4 or 5, this would be very patent heavy because new concepts emerges. You can actually protect those through patents. But as you move from 5 and onwards, we talk about deployment, we talk about demonstrations, we talk about contextualization of the technologies. And when we talk about all this, there are very, very softer aspects of the technologies. At times, you can't protect those. At times, you don't want to protect those through patents. And that's where the role of confidential information and know-how becomes very, very important. If we understand that how we leverage the technology development for the larger benefit of the organization, will give due consideration on both aspects. If I'm a startup, of course, it's very important for me that world knows me what I'm doing. And that's where patent becomes very important. But at the same time, as a startup, you also want to understand that you want to extend the IP-based protection to the extent possible. And that's where you also give due consideration what you are not going for patenting, what you are keeping as a confidential information, and more important, you also give due consideration to know-how. So in modern world, when we talk about technology transfers, rarely I have come across in my 2 decades of career, except in few industries, where people just typically talk about patent licensing. It's actually combinations of patents and know-how. And actually, in the modern world, these are interlocking assets. So it's very difficult to imagine a technology transfer package which doesn't talk about know-how. So that's how we need to understand, and that's how if we understand the basics, how it actually pans out in real time, we can strategize a better technology transfer practices. Thank you.
Right. I think you shared a very pertinent point about how it's important to also protect know-how and confidential information apart from patents. And I think EU has a trade secret law, which India still does not have. So there are, as you shared, there are differences in the laws in India and EU. And sometimes like there could be some legal hurdles also, or law regulatory hurdles that may come in the way of technology transfer. So I think I request Anushka to share with us about one of the regulations in the EU, which is the Technology Transfer Block Exemption Regulation. And how does it impact Indian companies who are looking to partner with EU companies?
Thank you, Srishti. Hope you can hear me well. So technology transfer block exemption regulation, what is this really? So shortened to TTBER, it is an EU technology law framework and competition law framework that basically provides a safe harbor from antitrust scrutiny for certain types of licensing agreements relating to intellectual property. Now, this may include patents, know-how, software. We will get into specifics of this. So what this really does is it applies automatically to agreements that meet the conditions exempting them from Article 101, Subclause 1 of the TFEU, which is the Treaty of the Functioning of the European Union. So what 101 TFEU does is it prohibits restrictive agreements. So these restrictive agreements could include agreements between undertaking, decisions by associations of undertakings, and concerted practices that may affect trade between member associations, member states, and have as their object or effect the prevention, restriction, or distortion of competition within the internal market. As you can see, this provision has a really wide application and contains a lot of discretion and subjectivity. And it is the cornerstone of EU competition law, and it ensures fair and open markets. So since it has a wide application, it in itself has an exemption clause under subsection 3. So unfortunately, the exception clause is also has a very wide application. So it says that the agreements that are exempted are the ones which have a positive effect on the production or distribution of goods or contribute to the promotion of technical or economic progress. Again, very wide. So to get away with this, all of this required high level of individual examination from the competition authorities, and it basically led to a lot of legal uncertainty. So the good thing is that under Article 103 of the TFEU, the Commission is empowered to enact something called block exemptions. The Commission has already enacted 6 of them, one of which is the technology transfer block exemption. So we will get into the specifics of it. So basically, TTBER is designed to encourage innovation by facilitating IP licensing. It also provides legal certainty for tech transfer agreements, and it prevents anti-competitive clauses that might restrict innovation or market access. As far as its application to Indian companies is concerned, it has a very wide application because even any two entities that enter into any a technology related licensing agreement, if the effects of that agreement have any effects in the EU market, in the EU technology market, the TTBR can apply to you, which is a good thing because it gives you a safe harbor, right? So the Indian companies need to be aware of this so that they can frame, even though it automatically applies, there are certain things which can exempt the application of it. So when any two entities, be it in the Indian market, be it the subsidiaries of an Indian company in the EU, or EU party and an Indian party enter into an agreement pertaining to technology transfer, they need to be very well aware of this, the TTBER and its application, because they would want it to apply to them. What needs to be really noted is that the European Commission and the Competition and Markets Authority has the right to fine a company up to 10% of its global group turnover for breach of competition law, and companies also can face exposure to actions for damages. And breach of the rules can also result in obviously significant reputational damage, and an individual being disqualified from being a company director, and in certain cases can lead to criminal sanctions as well. So to have a safe harbor is extremely useful, and if competition law aspects are not looked into properly for tech agreements, it can cause like lead to fines up to 10% of your turnover. So it's a really serious thing. Now, the way the impact is assessed on an EU market, it's called the impact principle. So it states that if an agreement outside the EU has a tangible effect on competition within the EEA, which is European Economic Zone, the TTBER may be relevant. So to determine the effect, the three things can be considered: the nature and extent of the agreement's impact on the EEA market, the market shares of the parties involved, and whether the agreement includes any hardcore restrictions. This is something I will get into it, like which I will get into later. So basically, companies entering into joint ventures and R&D, and companies wanting market access in the EU, and basically starting innovative technology-related businesses need to be specially aware of TTBER and its application, as I said before. And basically, understanding TTBER will ensure that your agreements are compliant and that you can the process of entering the EU market can also be smoother in this sense. And yeah, thank you so much.
Yeah, thank you, Anushka. I think competition law plays an important aspect in the technology transfer and IP licensing process. So you highlighted a very important concern, especially with the high penalties that the law provides at 10% of the global revenue. So now that I think we have understood the IP process, the technology transfer process, and what are the IP assets, both tangible and intangible, that we could protect, the competition concerns that you have highlighted, I think it's time to discuss some of the challenges that companies face when they are entering into cross-border technology transfer. So I would request Dr. André, who has very comprehensive experience in this field of global technology transfer, whether he can share with us that what are the challenges that companies face when they are doing technology transfer, especially with respect to difference in the cultures of different countries or difference in competencies between the academia and the industry.
Okay, with pleasure. You can hear me well?
Yes.
Okay. So, well, I'm coming from, I'm sorry to already jump into the thing. I'm coming from real life, meaning that technology transfer is a question of course, putting the things in the right order, putting the things in the right legal structure, having an agreement about the values and so on. We'll discuss about it, I guess, later. But in real life, whatever technology transfer is going to be occurring, the idea is to make money with it in some way. So that means that value is not a simple issue, and all these values that we determine when we do hypervaluations and so on are based on one thing, is assuming that things will go to the end and will work well. The reality of tech transfers, my experience is for many tech transfers from TRL 1 to TRL now and 9 and everything in between, is that things will go wrong. Whatever you like, whatever you will plan, things will go wrong. Some things will go wrong. So, and that's why it is important to plan and have a good idea of what can go wrong. What can go wrong is after 30 years of tech transfers in my life, I can tell you that there are a few things which are very important. The first one is that the parties do not always agree clearly upon what are the battery limits, meaning that they don't agree clearly about what technology we're talking about. Transfer means more or less a thing easy to define. But what is the technology we're talking about? I have an example in which technology transfer occurred from a European plant to a Brazilian plant, and somebody had forgotten that the River Atibaia in Brazil is generally not as cold as the Rhine in Europe, and that had a big impact on the thing. And nobody at that time was in charge of checking that, meaning that having an agreement about what is in, what is out, and then of course who is responsible for what and who is in charge. Responsible is not the right word. In charge of what is very important. Then competencies come into the game, of course, linked to what I just said. There needs to be a mutual understanding between the people, because there are people at the end who work together. There needs to be a mutual understanding. I never found anything better than organizing 3 days meeting on site. Of course, it implies a lot of cost. A few Europeans or a few Americans going to the US is not as going to Brazil is not easy, is not cheap, but this is very important. Having mutual understanding, real shake hands meetings, and then there is always a question of language and culture. Later on, I probably will talk about an example which is multicultural, and that's always an issue. So the project manager, project director needs to be aware of all these things before starting, and that's very important. Integrity of people, well, we continue to say so, but all this is included in the competencies and also the behavior of the peoples. Then, of course, then coming back to regulations, I have had several examples. Well, the projects are never a technical transfer that never takes 2 days and a half. It generally takes more than months, sometimes a year or something more. And during that time, our legal people are very good at changing regulations. And then when this happens, you better be reactive. And that's another thing that you have to be plan for the worst, and you'll make sure that you're okay. Budget, of course, is always a clear thing. Clarity about who pays what, and then integrity. Okay, I said I wouldn't pay for that, but it's my fault. I will pay for it. Has been real hurdles that I experienced. Documentation, you talked about know-how just a few minutes ago. It starts with a good documentation. I put it at the end of my list, but it's kind of thing that people never forget about. And then at the end, never forget that whatever you're going to put on the market, well, the market must be there. And if during the technology transfer you understand that maybe something is going on, some bug like in 2019 change a little bit the market, then another guy based in Russia decided again to change the market of energy and so on. You have to be adaptable. I have had to cancel tech transfers before the final installation started. It was just a wise management decision, and that's basically the hurdle. So once again, it's about technology, it's about competencies, it's about the legal framework. All these things need to be driven by one common goal, which is, are we going to achieve the business plan as much as possible as we wanted? And if not, what do we do to come back to it, or even to accept that we made a mistake and we don't do it? That's it.
Yeah, I think you shared a very important point, that it's important that the parties try to achieve the business plan, and if they can't achieve it, then maybe take a decision as to how to go ahead. So I think for technology transfer, I think the valuation of the IP plays an important role to understand how it links with the business. So I would request Mr. Umakanta to share with us that at what stage should we think about IP valuation in the whole process of technology transfer.
Thank you, Srishti, and good evening and good morning to everyone. Thank you for giving me this opportunity. But before I get into what stage probably companies should get their IP valued, let's understand why it is critical. Okay, if you look at back in 1975, if you look at the global balance sheet of corporates, around I think 17% was comprising intangible assets or intellectual properties. Now, fast forward today, as we speak, if you look at the global balance sheet of corporates, close to 85 to 90% of the balance sheet size is actually comprising of intellectual properties. That is why I think these IPs are becoming increasingly critical. And so all of us know, because we deal with this day in day out, I think tax authorities across the globe are also quite vigilant what transactions happening, right? They want to show, okay, is there has been any tax avoidance with respect to transaction where the valuation plays a critical role. Now, to answer objectively that when I think companies should value their IPs. See, I mean, whether it is valuation of IP business, or to that matter any asset, you'll only get it valued when you are expecting a transaction. Otherwise, just estimating a theoretical value has no meaning. So if you are expecting a transaction, and whether it is a third-party transaction or intercompany transaction. Now coming back, coming to intercompany transaction, one trend which we are seeing probably an increasing trend, enhanced IP transfer. Okay, I'll give a bit of background why it is becoming critical. Particularly I think you mentioned about startups. Now, as you know, I think early stage companies or startups, I think financing become critical, right? When they're developing their IPs, of course, they are looking for more funding, and they look for funding either through an equity or debt to look at, okay, how best they can leverage their IP. Now, if they're doing a transaction now, which is particularly intra-company or inter-region, then tax authorities will come into picture, right? You have developed an IP, and you think if you transfer from India to US, India to Austria, and there were tax incidents. So that is where enhanced IP is becoming more and more critical. What you say that let's say you have developed an IP from 2020 to 2025 in India. Now you want to transfer this to US or Austria or to wherever, you transfer enhanced IP. I say, okay, IP, with respect to 20 to 25 resides in India, and I transfer future IPs because I know why I'm transferring the IP. I'm transferring the IP. It could be a better regulatory framework, which I see as compared to India, or if I think that, okay, if IP is housed in a different geography, maybe it is easy to get financing. So that is where I think one trend which you are seeing, I think particularly intercompany transfer, enhanced IP, is becoming an increasing trend. Now, when it comes to at what stage you should transfer, we have seen IPs getting transferred across the life cycle of companies. Of course, your perspective changes, and the way you look at the value of the IP changes. I'll give a maybe simple example. I do, in addition to pharma, I do a lot of media and entertainment IPs. Now, typically when we say there are movies, right? Movies, we prepare business plan in 3 different times. When after an author finishes writing the script, you say, okay, hey, this movie looks like to be a movie which made, let's say, $100 million in a couple of years back. Probably this would be value $100 million. Now, next you prepare a business plan once the movie is produced. Third, after the probably theoretical release. So depending on the stage of the IP, you try to value the IP depending on what is the opportunity. Second, your prospect changes. Let's say you are particularly with respect to tech startups. If it is commercialization is yet to happen, when you are looking at an IP, they are talking about an opportunity. You are talking about an idea where your completion IP has yet to happen. So when you are valuing that IP, you look at, okay, hey, how much did I spend, in developing this IP? So far, I have spent $50 million. If I'm trying to transfer the IP because I'm yet to commercialize the IP, someone may pay me $50 million plus some, premium because I should expect a return on my development. At the same time, if I've already commercialized the IP, my value expectation will be different. But things changes when you talk about, let's say, pharma companies. Pharma companies, or life science companies, we look at IPs getting transacted at preclinical stage, phase 1, phase 2, or commercialization, because that is where actually you have a better way of estimating IP. Third piece, a lot of time what happens actually, there could be trigger based on which you think, okay, even though you had valued a IP just 3 months back, and but again you need to revalue the IP if you are transferring now because there is a trigger. What could be a trigger? Let's say there are 2 IPs, both are in let's say in life science in phase 2 trials, and just you got to know that one of the IP which had applied for phase 2 application or approval from US FDA got actually cancelled, which means the other IP, which is right now, in the process, the value changes completely differently because, you have the entire, blue sky for you to, target to. So based on certain triggers also, your IP changes. Now, what happens in the early stage when you are valuing the IP, because you will have limited information, you can look at cost approach, sometimes market benchmarks. Because what happens, let's say, particularly, tech startups, when they're developing the IP, the value of the company, nothing but IP value, because there's nothing else. Now, once they've developed the IP, started commercializing, you are seeing they have customer contract, the customer relationship, they've developed the supply chain. Now, the value of the enterprise is not only IP, they have a customer contract, workforce, and supply chain. So your approach changes. You don't only look at probably market benchmarks. You can look at, okay, hey, let me look at probably earning potential and try to carve out some of these other contributing assets and get to a value. So from that point of view, the way you look at the approach will completely change. So that's why you are seeing a lot of activities, and in fact some of these early stage companies filing for IPOs, also probably what do you call, demonstrating that, okay, IP has a is demonstrating its financing and its standing in the balance, not only in the balance sheet but also in the capital market. So I'll pause here, Srishti. I think I'll be happy to answer any question you may have with respect to this particular aspect.
Yeah, thank you. So actually, you shared a very important aspect about like IP valuation depends on the stage at which the company is, right? Even after a startup is launched, it may need valuation at different stages of its business growth, and depending on various triggers and depending on how the technology is, it is an early stage technology or it has been commercialized, then the value may increase. So I think this was our first round of discussion, and now we will jump into some of the challenges that companies and inventors face, and also some success stories of technology transfer. So I'll ask Dr. Tanja to share with us, the challenges that usually research institutions and inventors face when they're commercializing their IP.
So we have already heard from Munish. So you have, if you license, you have IP and you have also know-how, maybe trade secrets as well, that you actually don't want to give away. At the universities, if you compare them with the companies, it's very difficult to have trade secrets because we have pressure of publishing. It's the career of researcher. It's necessary for their career. So we never can tell them, so you are not allowed to publish because we want to keep it secret. So this is the first step. Because of that, we have to patent at very, very early stage, which means maybe technology readiness level 2, sometimes 3. And the next step is proof of concept. And what is in Europe still missing, it's proof of concept funding for this stage 2 and 3. We have fundings, but not enough. And we can see every year that there are lots of projects that need it, but the funding cannot cover everything. Which means also, if we don't get funding and we cannot develop at that stage technologies, we have later on the problems to commercialize it. So which means it's for us also very, very important that we also talk to the policymakers, that we raise the voice and that we ask them to keep an eye on the entire value chain from the beginning to the market, which steps are necessary, and how can we, for each technology, how can we foster the development. We also have different kinds of technologies. On the one side, we have very fast developing area, and on the other side, we have deep tech technologies, so which means they need several years to come to the market, which also means that sometimes when we talk to corporates, they are not interested because they say, okay, I don't need it. I have my production, I have my product, I don't need the technology. This is also sometimes important that the laws change so that the new innovation have place and can be developed as well. If we have a look at the startup spin-offs, sometimes they have great technologies, they have great investments, but sometimes they also found a conflict if the team doesn't work. Also, the company will not work And it's also the problem that technology develops further. Then we in Europe, we have also the problem of maybe too much regulatory. So we have different member states, we have different laws. And also with all these regulatory works, we are facing lots of challenges as well. And of course, I would say we are very, very good in developing the know-how, developing the technologies. But in the end, you have also to find people who are willing to risk the money, to invest in startups, also to bring them to this last step to enter the market. And I think now the Europe has lots of initiatives that are going in that direction. So thank you very much.
Yeah, thank you, Dr. Tanja. I think it's good to know that in EU there are initiatives that are encouraging startups. And as you shared that, one of the challenges is the regulatory challenges. So I would request Anushka to share with us some compliance or regulatory concerns. And what are the solutions to those issues or some of those issues?
Thanks, Srishti. So as I had mentioned about TTBER before, so Indian companies are facing quite a few regulatory compliance challenges when it comes to that. So what they need to keep in mind are that there are certain conditions under which TTBR protection is available. The first one of it being that the market share of each party in the agreement, in the tech transfer agreement, should not exceed 20% combined if both of them are competitors, and it should not exceed 30% if they are non-competitors, and that is individual market share when it comes to 30% individual market share. The other condition is there are no hardcore restrictions. These would include price fixing, output limitations, territorial or customer restrictions. If your agreement entails any of such restrictions, it might be anti-competitive, so the TTBR will not apply automatically. And the third is that the agreement should be limited to a technology transfer, and it should not include any kind of unrelated anti-competitive provisions, and its ambit should be limited to technology. Now, what is a technology transfer agreement really? So it is something that deals with technology rights, and technology rights may include everything from patent, utility models, designs, topographies of semiconductor products, supplementary protection certificates for medicinal products or similar products, plant variety rights, and software copyrights, or a combination of any of these. Technology rights must definitely be distinguished from IP rights and intellectual property generally. So, putting it very broadly, technology transfer agreement it's a license agreement in which one party allows one or more other parties to use its technology, which can be patent, know-how, all of the ones I mentioned before, for the production of goods and services. It must be borne in mind that this will apply only when it comes to the production of goods and services and not for any ancillary things. So when such agreements are drafted and reviewed, these things need to be kept in mind. Now, as I mentioned before, the EU applies the impact principle when it comes to the application of TTBER. So territorial scope of the agreement is very, very important. So special attention needs to be paid to the clauses pertaining to this. So it should be clearly defined whether the rights that the agreement pertains to are global, EU specific, or any member state or any other country specific. If so, for instance, the restriction of the territory or customer group into which or to which the licensee may passively sell contract products, with several exceptions, is very, very relevant. Permitted exceptions in this case, when TTBER will not apply, includes agreements reserving the license of passive sales into an exclusive territory or to an exclusive customer group, and agreements that prohibit members of a selective distribution system from selling to unauthorized distributors. So any kind of such exclusivity needs to be borne in mind, and it needs to be reviewed very, very carefully when it comes to the application of TTBER. And the license should definitely specify whether it is exclusive, non-exclusive, or sole, which is also extremely relevant. So this scope should be the lawyers must keep in mind that the scope should be very, very specific for the smooth application. And especially when it comes to exclusive licenses that might divide the customers or the markets across EU, they need to be specially avoided for its application. Like I mentioned, hardcore restrictions are a strict no-no. Price fixing, any kind of price fixing in the license agreement should completely be avoided. Then customer or territory restrictions in bilateral agreements between competitors should also be avoided. Now, there are certain clauses that need to be reviewed very, very carefully. Even though they are not strictly prohibited. That includes a grant back obligation, especially when it's an exclusive one. What is a grant back application now? In the context of licensing agreements, it's a provision that requires a licensee to grant back to the licensor rights to any improvements or new technology in the licensee develops based on the original license technology. And essentially, the licensee, after improving the license technology, must offer the licensor a license to use those improvements. Such a clause might prove to be anti-competitive, so has to be reviewed very, very carefully if it exists between two parties. If there is a non-compete clause which has its term beyond 5 years, that needs to be reviewed very carefully as well. If there are any restrictions that the contract entails, which are applicable even after the license expires, that is extremely relevant. And there are some list of non-exempted restrictions under Article 5 TTBER. They are the gray clauses, which also need to be specially reviewed, and they require some kind of individual assessment. So also one needs to remember that even if your agreement does not fall within TTBER, doesn't mean it's unlawful or anti-competitive on the face of it. If you remember, I mentioned initially that there is already an exemption within TFEU. So, but that requires individual assessment. So the agreements fall within the realm of that if TTBR does not automatically apply, but that requires a lot of time and individual examination for competition authorities to grant a go for it for that. So what Indian companies need to really keep in mind is what I have been saying throughout this, that the licensing agreements need to be reviewed very, very carefully. You would need expert councils to look into EU councils to look into the competitive elements, the anti-competitive results that it might have, and and even just defining the scope of it. So we at Timelex regularly review such agreements and draft such agreements, be it pertaining to IP licensing, technology transfers. It's a part of our routine job. So we have available and we have expertise in this area. So we are, and as Tanya also pointed out, the EU keeps increasing regulations every day, which is a huge, huge issue for companies because everyone is confused about the application. So even for instance, the TTBR is applicable till the end of 2026. That is when it will complete its 10 years of application. And as of now, it is under review for its extension, renewal, or revision for the next 10 years or so. So the Commission is already reviewing it. So if companies want to use TTBR as a strategic tool for Indian companies wanting to enter the EU especially, they need proper structuring of such an agreement to claim this benefit. And yeah, I think that's about it.
So thank you, Anushka, for sharing with us, the TTBR regulations and how the companies should draft their contracts to ensure that they get the exemption, right? And they are not anti-competitive. So I would request Mr. Munish to share with us what are from the India context actually, then what are the risks that licensees and licensors face while contracting? What should they do to mitigate those risks? And also if there are any sector-specific nuances or issues that they should keep in mind, while entering into licensing agreements.
Sure. Thanks, Srishti. So I'll start with very basic risk, and I think André touched upon this. I would say effective technology transfer would be where both licensee and licensors get benefited. And it happens at times that the context in which the technology transfer happens, the value creation aspect is not properly understood. And that's where the contextual understanding, the market understanding, how technology is going to be exploited is very, very critical. Otherwise, technology transfer happens on paper, and in real time, it doesn't lead to any value creation. So that's very, very pertinent. The second very important aspect or the risk that we need to understand is about appropriability and enforcement aspects. So, of course, the standards that we can apply in certain jurisdiction, you can't just replicate the same standards in other jurisdictions. The enforceability standards are very different in different parts of the world, and it's very important to understand when we are deploying technology transfer strategies. Why is it important? Because what you would be able to harvest in terms of value in a particular jurisdiction may not be necessarily same. And I'm talking more specifically from the legal frameworks, the legal enforceability standards across the jurisdictions. So that's very, very important that is taken into consideration in our technology licensing agreement, technology transfer strategies also, both from licensor as well as licensee's perspective. In fact, it's more important for universities or the TTO offices across the world to understand this particular aspect. The third very, very critical aspect is about the due diligence. And I'll talk about some practical issues here. And when we talk about due diligence, we talk about patents and we talk about also know-how. We also talk about that I'm just saying, I'm using a broader definition, confidential information or trade secrets. Let's go with patents first. Of course, how do you do the patent due diligence? You would do see that how easily these patents can be challenged, can be opposed or invalidated. That's the typical process how companies do it before getting into a deal. That's one part of the story. But the other very important aspect, and that this is largely in public domain, you can do that. Once you have the list of patents, you can do your own studies, you can get it validated from a third party also. But what about the know-how part? What about the trade secrets part? How would a licensee do the due diligence? Or even licensee wants to do it, the practical aspects of licensor, that how they can disclose it before getting the deal done. So these are very important aspects, and at times in industrial ecosystem, a lot of such technologies have a large interplay of trade secrets or the confidential information. So the risk resides there, and that's where we also need to deliberate, discuss that what could be the mitigation strategy in such a case. More importantly, there are certain, we don't have a trade secret law in India. We reside back on contract law or common law principles, or certain provisions in different statutes like IT Act or other acts. That's how we fall back upon. And similar, I would say, lacunas may exist in other parts of the country also. So if you're getting into a technology transfer deal which is involving confidential information, trade secrets, know-how, I think we need to have appropriate mechanisms in place so that we make sure that the deal is done in an effective fashion. Another very important aspect, and I'm talking about a very stretched technology transfer aspects many times when you sell your IPs also, and it happens with many companies, startups, that they sell IPs or they sell patents, and these might be at a very early stage of prosecutions or getting granted. So you might be interested in acquiring a startup, and typically when we talk about startup, they may not have a complementary assets. What they will have is largely the intellectual assets. Now, the risk could be that many times these technologies are so complex that, without having inbuilt provisions of reaching out to those inventors, actually it may becomes at times very difficult first to implement those inventions in real time. Second, also at times prosecuting those patents at patent office. So you need to make sure that you're building necessary provisions in your agreements to take into account all these aspects. Other practical aspects I've seen at times when people do jurisdiction specific licensing, people, organizations at times create bindings on derivative IPs, or they have non-compete clauses. And because they don't come in the main framework of the business, people typically ignore that. But these could have really serious legal repercussions for the businesses. So it's very important from a licensee's perspective that we understand what these restrictions would pose from a business standpoint when we are talking about restrictions on creating derivative intellectual property or non-compete clauses, because large organizations will have several subsidiaries associated. They will have several companies associated. So many times you agree on certain provisions that can stretch your obligations to our many other entities also. So it's very important that we give proper considerations on all these aspects. Another very critical aspects that we need to be concerned about is understanding where is the value and how much is the value and for how long we would be able to extract value. That's very, very important aspects. And I remember some of the deals, and I use this as a teaching simulation for my students. At times it happens that real value resides with trademark, and people get into licensing the patents, which could be on the verge of expiring, or other way around also. Many times the real value can only be realized when you have hands-on training, when you get into understanding that there would be a know-how transfer also to the licensee. So understanding this practical aspects is very, very critical to make your technology transfer process effective on both the parts. Thank you.
Yeah, thank you, Munish. I think I think Tanja, Anushka, and Munish have shared with us some challenges that, we face, some practical challenges from funding to really training the personnel who is going to implement the technology, to also due diligence. And, different countries can have different regulations and standards of enforcing IP. So it's important to keep all this in mind whenever any company is entering into technology transfer. So now that we have discussed the challenges, I think we have now the last two questions to Dr. André and Umakanta. Maybe I'll start with Dr. André, and I request both of you to share with us some success stories in technology transfer and what are your learnings from that. So over to Dr. André.
Okay, thank you. I will talk about a case which I like because it has been, as you will understand, it's not one technology transfer. It's interesting case where there are many actors. So let me just draw the big picture. It was several competitors around the world, 7 of them. I was part of one of them, had decided to tackle a big greenhouse gas effect because all of us together were generating something like, a huge amount of greenhouse gas effect in the world. That was way before. Well, it was before there were strong regulations, but we knew that we had to do something about it. Okay. So we designed together several processes. First of all, I let it already your legal people have a look at what, imagine what the competitors agreement was. You know, we were competitors, but working on the same technology, on a technology together. That was already interesting. Then, for one of the processes that we defined together, the producer of it was a catalytic process or whatever. The producer of the catalyst was a supplier whom we identified in the UK, one actor in addition to all the other competitors. Second actor we identified in the US. I'm sorry. The catalyst was in the UK. The pilot plant was then built in the US. So second actor, independent guy also, and nice contracts. Then we had to industrialize these technologies in several plants. My duty at that time was to industrialize it in our Korean-based plant. So we have France as a, let's say, R&D or whatever managing part. You have the UK as a producer of the catalyst. You have the US as generating the results on the pilot plant, and you have Korea as the site in which the plant was to be built. It has been a success. That's the first thing to say. It worked very well. We had no big hurdles. But the reasons why everything was working well is, first, there was a real incentive. There was a real business incentive for everybody to succeed. There was no competition. It was really where we were all aligned on the business plan. That's basically what we're going to say about that. There was a huge amount of technical documentation, not counting the huge amount of legal documentation, but that was passed us, and it was well done. So there was absolutely no problem in later discussions. So huge technical documentation, and moreover, we knew who were the people who had written that. There were patents also involved. We knew the inventors, we knew the people who had written that. So not only had we the documentation, but we also could get phone calls to the guys. Well, maybe we didn't understand exactly footnote 7 of page 69, something like that. So that was the first thing. It worked well because there was a huge documentation. Then I go back to what I said before. It worked well because at some point we became friends. There was the people from the catalyst. There was the people from the process. There was the industrial team on the Korean site, and we had, of course, a good team spirit. But I was the manager of that, but also very many difficulties in language, first of all, and also in comprehension and cultural aspects. We're dealing with very different cultures, even between France and UK. We have some things that don't work always the same way, but between the rest and Korea, it wasn't easy. So that here again, it was the second point was really after documentation and all the legal parts was the team spirit and the fact that whenever anything happened, many things happened, there was no friction. I mean, okay, let's solve it together. That was the idea. And we were competitors at that time. You know, that wasn't that easy because one of the catalyst producer was a competitor of us. And at the end, the right thing that really helped also was the right economics. Sorry. The valuation was done at that time, and we knew that any IP valuation or technology valuation will vary in the future because of many things. We all know that. And every time there was a hurdle on that, we sat together with the people from the economics and made sure that what we had forecasted as a budget was still reasonable and so on. So these are the three main points I would really insist on, is having the right legal, of course, the legal scheme and so on, but also the right technical documentation, having access to know-how of the people who have written the documentation, teamwork, as I said before, that's critical and crucial. building a real team. That was my job, to build a team around the world, and the right economics and no hurdles about. Well, we said it would be 1 million. Finally, it's 1.5. So what? Or did we stop? Or we continue? Or we find a way to solve it? These were basically the things that made the thing happen, and this plant is still running today, which is more than 20 years ago.
Thank you.
That's an example. I have many other ones, but I think this is the one worth sharing because of the complexity of the arrangement.
Yeah, I think thank you, Dr. André, for showing this, I think, amazing example where competitors from different countries became friends and were successful in this technology transfer deal. And also, as you shared, that the documentation was really strong, and they were all focused on the business incentive. So it's really amazing to see competitors work together. And as you share that, business incentive was also one of the aspects. So I will request Umakanta to share with us, how IP valuation has really helped in some successful deals, technology transfer deals.
I think the IP or technology transfer is becoming, as we discussed, key trends. And we need to understand, what are the drivers, right? If we look at the drivers, like initial stage of the companies, it becomes IP protection and funding. If I'm in India, I'm in the US, how is it going to happen? Let's say similarly, you talk about pharma companies, let's say access to talent pool, like I know this, what is this place name in Switzerland, Basilag, right? So it has become a hub of R&D for pharma companies, because you get access to talent pool is there with respect to pharma R&D activities. So these are the certain drivers which basically helps. Now in success stories we have seen, let's look at one of the, I think unicorn in India. Let's say we talk about Dream 11. Okay, it started in India. They move the IP, to US. Now we are seeing a lot of flip structure is happening. When initially they started in India, the IP was barely scratching the surface. The valuations will be probably tens of millions. Now move to US, business scaled up, become probably multi billion dollar companies. Now when let's say IPO or public market is getting stretched out, let's say in the Western world, now everyone is coming back to India because IPO market. So you are seeing these the success stories in terms of IPs getting transferred from India to US, coming back to India for liquidity point of view. I think there are many examples to see. I mean, in terms of IP financing, if you see, I think probably which are the sector, a lot of traction happening. Digital data processing, I think digital communication, medical devices, and semiconductor. These are the four sectors where you are seeing maximum IP financing happening. In fact, I was, before this session, I was looking at some of the applications received by Bank of America and JP Morgan with respect to IP financing. Now, over 50,000 applications for debt financing have been received, and over 50% of them have been actually, loan has been approved. This is demonstrating that IP, being used as a collateral, and when the transfer is happening, that's success stories. And one is, we look at early stage. Now there are a lot of success stories in distress scenario. I'll give one specific example. Probably all of us know this company called Toys R Us. Okay, it's a toy manufacturing company, and that it's a multi-billion dollar company, got into bankruptcy, right? What lenders they did, they they kept the IP. Okay, they spun off the IP, kept it separately. Okay, and things almost become nothing for the business point of view. Now we are seeing last 4 or 5 years, they started actually licensing out the IPs, not only in the US, across the globe, including India. We are seeing the revenue going or moving leaps and bounds, and that is where we are seeing a lot of success stories for distressed companies. We have seen companies like, in India, we have seen Future Group, right? The business, probably impacted, but, there are a lot of IPs which are primarily in the sense, in the nature of brands, okay, still has a meaningful value. Because as you know, the business may fail because of several reasons. But if you have created IP, which can actually go to a different kind of setup, because they have supply chain, they have other probably know-how, which can get attached to the IP to have a meaningful outcome. So in that way, we are seeing probably tons of transaction happening, and both in equity financing, debt financing, lot of, I think, probably slicing and dicing, right? For example, you look at in pharma life science sector particularly, earlier you used to see entire IP getting transacted. Now you are seeing, okay, IPs are getting transacted geography wise. Okay, second, you are seeing IPs are getting transacted. Okay, hey, you take the IP for this particular indication. Any further future indication, I have the rights, I can probably give it to someone else. So a lot of these, I think permutation, combinations, slicing, dicing happening, which is also probably demonstrating the success stories of IP transfer and IP probably financing.
Yeah, I think it's interesting to know that how IP is helping distressed companies by licensing them, and how it's also being used for debt financing. So quite interesting to know the developments in IP valuation. I think now we've come to an end of our panel discussion, and I would like to thank all the panelists, for giving us so much of their knowledge to us and sharing their experiences and with us. I think I would open the floor now for question and answer. We may have 5 minutes time for any questions and answers. We have, so whoever has questions can put it on the chat box. I think
we have one question by Mr. Rajneesh Kumar. So if
Mr. Munish, would you like to take it up? It's on the export control laws and technology transfer.
Yeah, can you read out the question? I can't.
What points one needs to observe under export control laws in technology transfer agreement?
Okay, so I think the way we need to look at the export compliances, there are technologies which are restricted from technology transfer perspective or from a material transfer perspective, and this list is easily accessible from each country's websites. The first and foremost is that if this is a restricted one, we can't do anything. So typically how we do it when we work with a lot of startups or when we work with a lot of SMEs across, we do this due diligence whether the technology in question falls in those restricted areas. Many times the answer is black and white. It's very clear that we won't be able to do anything. Sometimes there are gray areas, and in those gray areas, of course, we have to seek clearances from the export compliance authorities, and that's how we do it. So I think you need to get into the discussions and the agreement negotiations and the licensing negotiations once you have clarity on this. So that's a typical way we handle it. I don't know if other panelists have any other contrasting views on this.
I agree with Mr. Munish, and one of the things you can add on is there are some royalty, the value of the royalty or the licensing fee sometimes is determined by the FEMA regulations or the FEMA law in India. So that is something you can keep in mind to determine the licensing fee or the royalty fees.
The participants, any questions, they can raise it because we have some time, or otherwise, due to paucity of time, you can send a mail, we will forward it to them and we will definitely reply to your query. So if any other question is there, you can raise your hand or you can write in the chat box. So our audience is all sorted. So if there is no question, then we will request Mr. Singhania to sum it up and propose the vote of thanks formally.
I thank you, everyone, every speaker, and also the participants who have participated. I thank the EU Chamber of Commerce, Ms. Renu Shom also, Dr. Roni Shom, and Ms. Sohail Nathani to give us this opportunity to organize this conference, and also to all the speakers who have really given valuable comments and suggestions, and also shared their knowledge, which is, I think, will be useful for Indian companies who are looking to invest in EU or take technology transfer, or at least they will come to know about IP valuation, which is another important aspect in today's commercial world. Thank you.
Thank you.
Before I would request Mr. Nathani to kindly, switch on his camera so that we can at least take a picture. Thank you to everyone, and we'll also send a question, feedback form to the participants, and we'll request I kindly respond to it. That will help us to organize more sessions like that. Thank you.
Thank you.
Thank you, everyone.
Thank you so much, Srishti. Thank you, everyone.
Thank you.
Thank you, everyone. Bye.
Bye.
Bye.